International Moot Court Competition 2021. We will now commence with the Saraswati Vandana.
या कुन्देन्दु तुषारहार धवला या शुभ्रवस्त्रामृता या वीणावरदण्डमण्डितकरा या पद्मासना या ब्रह्माच्युतं शङ्करं प्रभृतिभिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेष जाड्यापहा।
As we look forward to a competitive and enthralling round of arguments, without any further ado, I would like to request the honorable judges and finalists to commence with the final round of arguments. Thank you.
May I start?
Yeah.
Good afternoon, Your Excellencies. I am the agent appearing on behalf of the applicants, the People's Democratic Republic of Valedictory, and it is an honor for me to appear before this court. Your Excellencies, this court today has convened in the light of the serious damage to property, health, and environment suffered by the applicants. Furthermore, a restriction has been sought to be imposed on the applicant's freedom of enterprise and the applicant's freedom and right to put the island of New Peravia to good use. Over the next 12 minutes, I will be addressing this court on the key aspects of our case with regard to the question concerning the respondent's liability for the damage caused by the impact of the space object under international law. I will then yield the floor to my co-agent, who in the subsequent 16 minutes shall address this court with regard to the question concerning the applicant's entitlement to conduct moon mining operations under international law. The third question concerning the alleged nature of the alleged militarization of the island of New Peravia and the validity of the respondent's countermeasures shall also be addressed by my co-agent. Consequently, we reserve 2 minutes for rebuttals. Your Excellencies, may it please this court. The respondent in August 2018 launched its most ambitious project, the Simpan, from its base in the island of New Peravia. Owing to its technical defaults, the Simpan failed, resulting in the creation of massive amounts of debris in space. The corresponding impact of the same was responsible for the bushfires that spanned millions of hectares, causing severe damage to property, health, along with several environmental and biodiversity hazards in the territory of the applicant. Your Excellency, in addressing the first question as to the liability of the respondent, I shall be making 3 key submissions. First, that the respondent is liable for the damage caused under the provisions of the Liability Convention of 1972. Second, that the respondent is liable for the damage caused under the provisions of the Perevian Accord, hereinafter referred to as the Accord. And third, that the respondent is liable for the debris in space under the provisions of the Outer Space Treaty of 1967, hereinafter referred to as the OST. Allow me, Your Excellencies, to elaborate on these points. If Your Excellencies would most kindly refer to submission number 1.2 in page number 2 under arguments advanced of the memorandum, it is observed that Article 2 of the Liability Convention holds a launching state absolutely liable for the damage caused by the impact of its space object on the surface of the Earth. A launching state has been defined as a state from whose facility the launch operation has been conducted. The term space object refers to space debris as well. The damage caused has been defined to mean damage to health, property, and the environment. The damage caused must bear a causal connection to the impact of the space object. It has been observed in the settlement of claims between Canada and the USSR for the damage caused by the Cosmos 954 satellite that the proximity of the space object or its remnants is a clear indication of the cause of the damage. Your Excellencies, in the instant case, the respondent launched the Simpan from their base in the island of New Peravia. Owing to its certain defaults, the Simpan disintegrated, causing the impact of large chunks of debris, which resulted in damage to the health, property, and the environment of in the territory of the applicants. Therefore, Your Excellencies, this is a clear case which attracts the liability under the provisions of Article 2 of the Liability Convention. All the required parameters are satisfied beyond doubt. A, there is a launching state, the respondent who launched the Simpan from their facility. B, there is a space object, the Simpan and its consequent debris. C, there has been damage caused to another party, the destruction of property, the hazards to health and the environment that has been suffered by the applicants. And finally, D, the damage bears a causal connection to the interference by the space object. The bushfires were fundamentally and materially caused by the impact of the burning chunks of debris.
Excuse me, but the two things are different. One is that you talked about debris in space, and the second is that you talked about the damage that was done on Earth.
Yes, indeed, Your Excellency. The Liability Convention has been invoked to give absolute liability for the damage caused by the impact of the debris on the surface of the Earth in the territory of the applicants, Your Excellency.
Can you show us Article 2 of the Liability Convention?
Yes, indeed, Your Excellency. If I may be allowed to share my screen. Much obliged, Your Excellency.
Or read it out.
Yes, Your Excellency. Article 2 of the Liability Convention states that a launching state shall be absolutely liable to pay compensation for damage caused by its space object on the surface of the Earth or to aircraft flight.
So it covers both.
No, Your Excellency, Article 2 of the Liability Convention only deals with the impact of the space debris of space objects on the surface of the Earth or of any aircraft in flight. In the instant case, Your Excellency, the impact of the debris has occurred on the surface of the Earth, therefore entitling the applicant to invoke the claims under the Liability Convention, Your Excellency.
Okay.
Now, para 6 of the problem states that a week after launch, the Simpan broke apart and fell to the Earth. Since it happened 1 week later and it had been orbiting successfully for as much as a week, can you say that there was liability? It is not that there's any negligence on their part. Accidents do happen.
Your Excellency, in this regard, it is submitted that the liability under Article 2 is one of absolute rather than fault. Therefore, the mere fact that damage has been caused to the applicants by the impact of the space object is sufficient to claim liability under the provisions of the Liability Convention of 1972, Your Excellency. May I proceed, Your Excellency?
Have you quantified your claim?
Your Excellency, we have not quantified the claim as it is a function to be addressed by the Claims Commission to be set up under the Liability Convention, Your Excellency.
And that is provided for in the convention?
Yes, Your Excellency. Article 12 of the convention allows a Claims Commission to be set up to quantify the amount of damages to be claimed by a claimant state, Your Excellency. May I kindly proceed with the submissions, Your Excellency? Much obliged. Your Excellency, in this regard, I would also like to submit that the only possible means of exoneration from the absolute liability is provided for under Article 6 of the Convention, which allows exemption if there is gross negligence or an act or an omission done with the intent to cause damage on the behalf of the claimant state. If such serious allegations are presented before this court, Your Excellency, the standard of proof that is required to be adopted is the highest standard of beyond reasonable doubt, as previously done by this court in the Corfu Channel case. Your Excellency, in the instant case, the applicant is an innocent bystander to the manufacture in all events, starting from the manufacturing to the launch of the Symphony. Therefore, Excellency, it is submitted that there is no act on the part of the applicant which can. May I proceed? There is no act on the part of the applicant which can qualify as an act of gross negligence beyond reasonable doubt. If there are no clarifications, Your Excellency, I shall now address the second submission under the first question before this court. Much obliged, Your Excellencies. Your Excellency, the respondent is liable for the damage caused under the provisions of the Peregrine Accord. In contending so, I shall make two key submissions. Firstly, that the respondent has violated their obligations under Article 17 of the Accord. If Your Excellencies would kindly turn their attention to submission number 1.3.1 on page number 4 under arguments advanced in the memorandum, it is observed that this provision imposes on parties an obligation to avoid harmfully affecting the environment of the earth by any means. Your Excellencies, such an obligation has been interpreted to be a positive obligation of due diligence in the Seabed Mining Advisory Opinion, as well as in the Gapchikova-Nagimaros case. States are required to exert their best possible efforts to minimize the risk of occurrence of harm. The level of due diligence to be exercised varies with the nature of the activity and the capabilities of the state engaging in the same. Your Excellency, in this regard, it is to be noted that space activities are recognized to be ultra-hazardous in nature. Therefore, the level of risk associated with it is also highly risked.
How do you say that they did not exercise care? Because they have carried out a test several months earlier, and then it was not immediately after they found errors earlier, but now after many months they've again sent Simpan into space, and the errors that occurred this time, or the difficulties that arose this time, were different from the ones earlier. So they had not arisen earlier. So therefore they have taken proper care.
Your Excellency, I understand your concern, but it is a point to note that the respondents conducted just a single test launch for the launch of a project unprecedented in scale in the history of mankind's space operations. The data concerning the errors revealed by the said test launch was not recoverable. Furthermore, in the event of the failure of the said test launch, the respondent proceeded to launch the mission within a mere 5 months without conducting a multiple test launches to check if the errors had been rectified completely to the best of their ability. Therefore, Excellency,
the earlier errors were rectified.
Your Excellency, the fact that the data concerning the initial test launch was not recoverable by the respondent serves a serious impediment to the complete rectification of the errors revealed in the initial test launch as well. Therefore, Excellency,
is there any standard of proof required for fasten the liability?
Your Excellency,
you said now, insofar as you are concerned, it is to be proved beyond a reasonable doubt. No?
Your Excellency,
negligence, etc. You said. So, what is the standard of proof to fasten the liability?
Your Excellency, the standard of proof of beyond reasonable doubt is to be adopted by this court in the face of serious allegations such as gross negligence or an act or omission done with the intent to cause harm. In dealing with cases of lack of due diligence, the ICJ has previously applied the standard of preponderance of evidence. Therefore, Excellency, it is submitted that this is the standard to be applied.
You say that there is intention to cause harm.
Your Excellency, this is not a matter of intention, but a matter of the respondent not complying with their obligations that are demanded by engaging in such a hazardous activity. The respondent was to adhere to the standards of due diligence, which were exert their best possible efforts to minimize the risk of occurrence of harm, which in this case they did not do.
Okay.
Your Excellency, may I?
Yes.
Your Excellency, I would like to request a 1-minute extension to summarize my third and
Yes,
final
go on,
argument.
go on.
Much obliged, Your Excellency. If Your Excellencies would most kindly refer to submission number 1.1 on page number 1 under arguments advanced, it is observed that Article 9 of the OSC places an obligation on states to not harmfully contaminate the environment of space by giving due regard to the rights and interests of other parties. The court in the Gabchikawa Nagimaro's case has stated that the duty of control and preventive action to avoid harmful contamination of the environment has been recognized to be a part of customary international law. The duty to give due regard has been interpreted to be an obligation of due diligence in the seabed mining advisory opinion case. Your Excellency, as submitted previously, the respondent did not adhere to the standards of due diligence which is demanded by engaging in a space activity. This led to the creation of massive amounts of debris in orbit, which has been recognized to be a form of harmful contamination in the United Nations General Assembly resolution. Therefore, Your Excellency, it is submitted that the respondent has violated their obligations under Article 9 of the OSC. If there are no further clarifications, Your Excellency, the sufficiency with regard to the second question shall now be addressed by my co-agent.
Okay.
Much obliged, Your Excellency.
That is on that Peridian Accord.
Your Excellency, the second question before this court deals with the applicant's entitlement to conduct moon mining operations under international law, Your Excellency.
Okay.
Can we just take a minute to do our marking?
No, Anil, we'll finish with one team and we'll do it.
Okay, we have to actually mark for each individual.
Right. But okay, you want to do it just now?
Yes, because it's fresh in the mind.
Okay. Yeah, I've done mine.
Yes, I've done mine.
Yes,
Your
now the second.
Excellencies, I am the second speaker for the applicants. I respectfully seek your permission to proceed with my submissions.
Yeah. Please.
Much obliged, Your Excellencies. Your Excellencies, in addressing the second question as to whether the applicant is entitled to the activity of moon mining, I shall be making a broad submission that the activity of moon mining is permitted by the OST as well as the Peruvian Accord. Under this submission, I shall make 3 points of contention. First, that the activity of moon mining is covered by freedom of use and exploration as envisaged in Article 1 of the OST. Second, that the activity would be carried out in the common benefit and interest of all countries. And third, that the activity of moon mining is appropriation of resources and not national appropriation as envisaged in Article 2 of the OST. Advancing the first point of contention, Your Excellencies, Article 1 of the OST talks about the freedom to use and explore, which is broad in nature and includes commercial activities. The freedom to use contains the possibility for an entity to utilize outer space as well as its resources in order to accommodate commercial as well as non-commercial needs. Your Excellencies, there are no specific provisions in the OST that excludes commercial activities of the state parties. Article 18 of the Peruvian Accord, which both states are party to in this regard, compounds this interpretation. Your Excellencies, it is of importance to note that Article 18 talks about activities for purpose of use and exploration anywhere on or below the surface of the moon. In applying the ordinary meaning of the words anywhere on or below its surface clearly points to the fact that Article 18 allows parties to undertake functions that are essential to moon mining. Your Excellency, it is also a respectful submission that preamble of the accord should be considered an important means of aiding the interpretation of the same. The preamble of the accord talks about activities that allow for exploitation of moon's resources. Your Excellencies, as per BC Article 31, Clause 2 of the Vienna Convention of the Law of Treaties, the preamble serves as a tool that aids in interpretation of treaties. And hence, Your Excellencies, it is our humble submission that commercial activities do fall under the ambit of freedom of use and exploration. Your Excellencies, it is our second point of contention that the activity of moon mining would be carried out for the benefit and interest of all countries. Your Excellencies, as mentioned previously, Article 1 of the OST states that parties have the freedom to use and explore moon and celestial bodies, and this would be carried out in the interest and benefit of all countries. Your Excellencies, this obligation is to be interpreted in a general sense, and it does not stipulate a requirement as to how these benefits are to be shared amongst parties.
So what do you think is the manner in which the benefits, in what manner do you think the benefits can be shared? If you're going to do it, are you going to just distribute the benefits to everyone else and keep very little for yourself?
Your Excellencies, in the instant case, the undertaking of moon activity was to be carried out for extraction of natural resources like helium-3, dust, and rocks. And this would definitely serve a commercial purpose of the applicants. However, it would also be in the interest and benefit of all countries because resources like helium-3 has immense potential to generate energy without any radioactive waste. And this would enable to bring down global pollution to a massive scale, which would be in the benefit and interest of all countries. Your Excellencies,
but you will make
adding
a huge
to
profit from this.
Yes, Your Excellencies. We would make a huge profit. However, Your Excellencies, this profit-oriented activity does fall within the freedom of use and exploration, and it is carried out as an extension to common benefit and interest of other state parties as well.
What does the preamble say? Preamble to the treaty?
Your Excellencies, may I kindly refer your attention to paragraph 11, page number 11 of the compromise, where the the preamble to the Peruvian Accord has been given. And it states that bearing in mind the benefits which may be derived from the exploitation of natural resources of the moon and other celestial bodies.
Bearing in mind what?
The benefits which may be derived from the exploitation of natural resources of the moon and other celestial bodies.
Okay. Yes. Yes, continue.
Your Excellencies, shall I proceed with my submission?
Yeah.
Much obliged, Your Excellencies. Your Excellencies, it is my third point of contention under this submission that the activity of moon mining constitutes appropriation of resources and not national appropriation as envisaged in Article 2 of the OST. Your Excellencies, prohibition on national appropriation as laid down in Article 2 applies to territorial claims over the moon or any parts of the outer space. Your Excellencies, in conducting the activity of moon mining, there would be no claim over territory or sovereignty in any aspect. The appropriation is exclusively going to be taken in with regard to the resources and not to the territory in question. Your Excellencies, in light of the legal principles on the matter of appropriation...
But once you utilize the resources, then that territory will be of no value to anyone else.
Your Excellencies, the kind of resources as previously mentioned that the applicant wishes to extract are such that they are inexhaustible in nature, such as dust, rocks, and helium-3. And further, Your Excellencies, adding to that submission, the manner...
Everything is exhaustible. The Earth is much larger than the moon is, and yet our earthly resources are getting exhausted.
Yes, Your Excellencies, indeed. But however, Your Excellencies, in the instant case, from the factual matrix, it cannot be inferred the nature of the appropriation or to what extent this appropriation is likely to take place. Your Excellencies, in that regard, it is humbly submitted that it cannot be inferred that this exploitation would take place to such an extent as to exhaust these resources. Your Excellency, shall I proceed with my submissions?
Yes. Yes.
Much obliged, Your Excellencies. Your Excellencies, in light of the said submissions, I humbly submit that use of resources would not be national appropriation because mining can be conducted without claims on territorial sovereignty, and in the absence of an express prohibition on use of space resources, the right to free use provided under Article 1 of the OST permits that activities such as commercial space mining is allowed and hence is permitted. Your Excellencies, if there are no further questions on the second submission, I would like to address the third question before the court.
Yes.
Much obliged, Your Excellencies. In addressing the third question of whether the applicant was in contravention of the UN Charter and other applicable laws in militarizing the island of New Perivia, and whether the countermeasure undertaken was valid under international law, I shall be making two key submissions, Your Excellencies. First, that the act of the applicant does not constitute as a violation of Article 2, Clause 4 of the UN Charter or the Peruvian Accord. And second, that the respondent's countermeasure was not valid under international law. Your Excellencies.
But para 11 of the compromise says that you had, in addition to military forces on the island, also deployed 2 aircraft carrier warships that functioned as sea air bases. So isn't that a gross violation on your part? And that will definitely require some response from them. Do you want them to go to war against you?
No, Your Excellencies. In addressing that question, I shall address that question in greater detail in my submissions. However, Your Excellencies, to answer that question, I would like to respectfully submit that there is a recognized exception to this rule of express prohibition against military deployment on the island, which states that military can be deployed if it is undertaken for peaceful purposes. Your Excellency, it is also of importance to note in this regard that both state parties have equal territorial sovereignty over the island of New Perivia, and there is no border demarcation. There is only a separation in the governance of the territory in order to facilitate administrative convenience. Your Excellency, in this regard, the applicant state has merely deployed territory on its Constitution Day, and it has deployed military on the territory that it has title over. Your Excellencies, in dealing with this question, I shall give examples of state practice in this regard to show that threat of force can only be applicable.
Would you say?
Pardon, Your Excellencies? Pardon, Your Excellencies, could you repeat the question?
Would you say that strict body cavity searches are peaceful purposes?
No, Your Excellencies. However, Your Excellencies, the claim that
body cavity searches peaceful purposes?
No, Your Excellencies, they aren't, it doesn't come under peaceful purposes. However, Your Excellencies, there is no evidence to show that this was conducted by the state of the applicants and that this activity is attributable to the state.
Then who did it? Is it some third country? Is it India that did it?
No, Your Excellency, it cannot be inferred from the factual matrix that this activity was attributable to the applicants and I would like to refer your kind attention to paragraph 11 of the compromise. It has been stated that certain paramilitary officers and officials subjected the Eritrean government officials to body cavity searches. However, Your Excellency, such a claim is refutable on the simple idea that certain paramilitary officers that they claim to be Paraguayan citizens is an act that is not attributable to the state. Your Excellencies, shall I proceed with my submissions?
Yes.
Your Excellencies, there's ample state practice to show that threat under Article 2, Clause 4 of the UN Charter becomes meaningful and becomes provocative only when there is an express reference or there is a compellation. There is compelling by a state in order to fulfill a demand. Your Excellency, some state practice in this regard are as follows. Your Excellencies, in 1946, when the USSR deployed military troops on the Turkish borders, USSR demanded that Turkey revised its international regime for the Turkish Straits and compelled Turkey to go back on the sovereign rights that it had over the Turkish Straits. Similarly, Your Excellencies, in the Iraq-Kuwait conflict of 1994, before sending troops, Iraq explicitly mentioned that it would retaliate because of the economic sanctions that was imposed on them and compelled Kuwait and the other Arabic nations in order to go back on these sanctions. In the presence of such an express threat, it was opined that this constituted a threat of force. However, Your Excellencies, in the instant case, the applicant deployed military on its own territory on Constitutional Day, and there was no explicit reference.
It's
there
not
was
on
no
its own territory. It was in the water. Deployed 2 aircraft carrier warships. So if they're on the sea, that's not your territory.
Your Excellencies, waters within 12 nautical miles of the territory would still be.
But this is common territory. So if the waters belong to both or can be treated as belonging to both, then you're also trespassing on their rights.
Your Excellency, in this regard, it is a submission that the exception to the military deployment under Article 5 would come into picture. Your Excellency, if I could kindly refer your attention to paragraph 6 of the compromise, it has been mentioned that the disintegration of Simpan caused massive bushfires over the subcontinent of New Perivia. Your Excellency, it has also been expressly mentioned in the last line of paragraph 6 of the compromise that there was significant bushfires caused in Perigaitis. Your Excellencies, the citizens of Perigaitis live on the island of New Perivia. The fires were caused over the Perivian subcontinent, which includes the island of New Perivia. Your Excellency, the applicants owe a duty to its citizens in order to protect their citizens from bushfires that was started by the respondents. And it was in this regard that aircraft carriers were deployed because of the capacious nature of aircraft carriers that it can be used for large-scale rescue operations. In this instance, Your Excellency, it is a submission that deployment of any military by the applicants was done within this recognized exception to the prohibition of military on the island of New Perivia. Your Excellencies, I noticed that there is a paucity of time.
When are aircraft carriers used for rescue operations? Since when are aircraft carriers used for rescue operations?
Your Excellencies, aircraft carriers are known for the kind of capacity it has in order to hold certain equipments, and it is used in warfare as well. We respectfully concede to that, Your Excellencies. However, in the instant case, without a reference to any threat or without a reference to any sort of demand to concede to any of the demands made by the applicants, it cannot be inferred that this was a threat and that this would come under peaceful purposes. Your Excellencies, seeing that my time is running out, shall I ask, I respectfully ask for an extension of 1 minute to summarize my arguments.
Yeah.
Much obliged, Your Excellencies. Your Excellencies, under the question of validity of the countermeasure that the respondent undertook, Your Excellency, for a countermeasure to be valid, it has to fulfill certain requirements. First, it must be taken by a state which has suffered direct or indirect injury as a result of an international wrong that is committed by the other state. Second, the injured state must call upon the responsible state to fulfill its obligations and offer to negotiate in good faith. Third, it should be proportionate to the harm suffered. And finally, the effects must be reversible and short-lived. Your Excellencies, in the instant case, the respondent unilaterally assumed that this was a threat of force, and they shut down Perinev and consequently shut down communication and broadcasting all across our state. Your Excellency, in addressing the second point, Your Excellency, The respondent state did not offer to
No,
negotiate in good
it says
faith.
in para 13 that both the nations attempted to resolve the issues through high-level consultations. So there were negotiations.
Yes, Your Excellencies. However, this was not preceding the shutting down of Perinev. Your Excellencies, this happened after Perinev was shut down, and there was international pressure on both countries to resolve their disputes. Because the respondent state had declared de facto war with the applicants.
Did you inform them before you deployed your aircraft carriers? Did you try and negotiate with them at that time?
Your Excellencies, as mentioned in Article 5 of the Peruvian Accord, there was no obligation on us to respond or to notify them that we were deploying military for peaceful purpose on territory that we had territorial sovereignty over.
But does the accord say that they must inform you before they shut down systems?
Yes, Your Excellency. Article 47 of the Accord states that if failing to adhere to any of the obligations would have to require a notification to the injured state. And additionally, Your Excellency, in order to make a countermeasure valid, it is imperative that the state has to notify the other state in order to coerce the state to fulfill its obligations.
So what obligation did they have?
Your Excellencies, they had the obligation to negotiate with the applicant side in good faith to resolve the situation before we shut down Perinev.
Okay.
Your Excellencies, if I may submit the prayer on behalf of the applicants.
Yes.
Much obliged, Your Excellencies. On behalf of the People's Democratic Republic of Perigitis, I respectfully request the Honorable International Court of Justice to adjudge that the respondent is liable for space debris and damage caused by disintegration of Simpan, that the applicant is entitled to conduct the activity of moon mining under the Peruvian Accord, and thirdly, that the alleged militarization of the island of New Perivia does not qualify as threat or use of force under Article 2, Clause 4, and that the countermeasure that was undertaken by the respondent is invalid. Your Excellency, the People's Democratic Republic of Perigitis also respectfully requests the Honorable International Court of Justice to pass any order as it deems fit in the interest of equity, justice, and good conscience. Thank you, Your Excellencies. It's been an absolute honor.
So Anil will do the marking?
Yes, please. I'd like to do.
Yes.
Good evening, sir. I would like to confirm as to whether I'm audible before I begin, and also that my researcher has the permission to share the compendium when required. Thank you, sir. A very good evening to the distinguished members of the bench. This is Agent, appearing for the Federal Union of Erudnitis, the respondent, in the instant case concerning the liability for Simpan, interpretation of the accord, and other matters. I will be addressing question 2 relating to interpretation of the accord, borrowing 12 minutes of this court's time. My co-agent will consider question 1 concerning liability for Simpan and question 3 relating to use of force and countermeasures, borrowing 18 minutes of this court's time. Question 2 before this honorable court is whether the applicant is entitled to conduct the activity of moon mining under the Peruvian Accord. We submit that the applicant is not entitled to conduct the activity based on 3 grounds. Firstly, relying on the ordinary interpretation of the accord. Secondly, considering that the principle of non-appropriation is a structural norm. And thirdly, applying the common heritage of mankind doctrine. Your Excellency, I would first like to point out two relevant facts to this issue. Firstly, Mr. Plusios Anthropos, a Perigetian citizen, incorporates Arthur Inc. and then goes on to state, if I may quote, from page number 7, paragraph 7 of the compromise, we have the stuff if you have the money. Dust, rocks, or helium-3, we are the only ones who can get it all. It's a lunar gold rush and we'll be there first. Unquote. The second fact, Your Excellency, is that subsequent to the issuance of this statement, an executive order was issued by the president of the applicant state declaring that they don't view outer space as global commons. I would now like to proceed with the first limb of my argument. Article 31 of the Vienna Convention on the Law of Treaties provides that treaties must be interpreted in accordance with the ordinary meaning given to its terms. In order to understand the ordinary meaning of the Peruvian Accord, analogous provisions of the Moon Treaty or the Outer Space Treaty will be examined. I will be referring to Articles 14 and 21 of the Accord, which correspond to relevant articles under the Outer Space Treaty and the Moon Treaty respectively. Your Excellencies, Article 14 of the Accord provides that exploration and use of the moon shall be for the benefit and in the interest of all countries. A crucial question is the nature of obligation cast on states that conduct such activity in outer space. Your Excellencies, we submit that the obligation is positive in nature. Your Excellencies, if I may kindly ask you to refer to page number 337 of the compendium. Can you kindly scroll up? Page number 336. Your Excellencies, this is an excerpt from the book authored by Dr. Ricky Lee. He refers to the arguments made by Professor Stephen Jarov, which my learned counsel for the applicant has placed reliance on, as to how the obligation in question is general in nature. However, if we now proceed to page number 337. 337. Can you kindly scroll further? Yeah. Your Excellency, referring to the part in green, the author specifically notes that this argument will not sustain for two reasons. One, that the usage of the word interest in the provision is used in a plural form, therefore representing specific and identifiable interests of various countries as compared to a general interest of mankind. The second reason being that although this provision is couched in aspiration, when read with the specific doctrine, that is the common heritage of mankind doctrine, Your Excellency, the obligation translates to one of a positive nature. Therefore, Your Excellency,
exactly would that mean in practice? Because every country will not have the technology and will not have the money to do it. And suppose the country does undertake this exploration, are they not entitled to earn some money for their efforts?
Indeed, Your Excellency. Your Excellency, this is the principal approach that also a lot of developed countries have taken into account, referring to the classic laissez-faire approach, or the theory that if they were to engage in exercise of labor, they will have to be reaping the benefits of the same. However, Your Excellency, keeping in mind certain other developing nations, or so to speak, the respondent nation in the present circumstance, it would be disadvantageous if the respondent does not have the adequate technology for various reasons and is not allowed to pursue the same activity on the moon. However, Your Excellency, in the alternative that if the applicant pursues these activities on the lunar surface, the respondent must be either entitled to benefits of the same, or in the alternative, must be provided with some form of technology sharing mechanisms, which will also enable the respondent to pursue a similar activity on the lunar surface, Your Excellency.
But country A does not have to give country B its technology. If country A is able to exploit resources and those resources are available to everyone at a price, but they're available to everyone, then supply increases. If supply increases, then it's beneficial to everyone. Of course,
Indeed,
everything comes with a cost.
Your Excellency, this is a classic. Indeed, Your Excellency. Your Excellency, this is a classic efficiency versus equity argument. However, keeping in mind the common heritage of mankind doctrine, benefit sharing is extremely important, and the same has to be undertaken on the grounds of equity, Your Excellency. And the nature of this doctrine is customary nature, which requires a specific compliance of this obligation and this doctrine, Your Excellency. Therefore,
but no regulations or no norms have been laid down for distributing the benefit. Have they been?
Indeed, Your Excellency. It is the very argument of the respondent that under the Perry-Win Accord, there has been no contemplation of the specific benefit sharing mechanism, Your Excellency, and in the absence of which, any appropriation by the applicant would constitute a violation of the accord, Your Excellency. The respondent would contend that when the benefit sharing mechanism has to be arrived at by the applicant and the respondent by way of consultations or any form of addendum to the present agreement, keeping in mind the CHM doctrine, the Hague building blocks, and also the Vancouver principles, which adopt these similar benefit sharing mechanisms, Your Excellency, which, when undertaken as an addendum to the present agreement, will allow the applicant to pursue these activities on the lunar surface, Your Excellency.
But that can be done later. The sharing of benefits can be done later when one knows what the benefits are. Suppose country A carries on an activity, and if they lose money in an attempt to earn and in order to exploit resources, suppose they lose money, then will country B or the rest of the world contribute to that? I don't think they would.
Indeed not, Your Excellencies. I would, in answer to this question, draw your attention to page number 830 of the compendium, Your Excellencies. Paragraph 244 of the compendium refers to. Your Excellency, in the 2019 Legal Subcommittee report, one of the agendas was specific in reference to space mining, Your Excellency, and one of the delegates has gone on to observe, if I may so read, the view was expressed that, at present, space resources were accessible only to a very few limited number of states and to a few private sector actors within those states, and that it was therefore relevant to assess the impact on the world economy of applying the doctrine of a first come, first served, as it would create a de facto monopoly and would thus be in absolute contradiction with the letter and spirit of the Outer Space Treaty. Your Excellency, applying the similar analogy to the present circumstances, the statement made by Mr. Plusios Anthropos would be directly relevant to the fear raised by this delegate, Your Excellency. However, answering to the question regarding sharing of costs and sharing of benefits, I would like to state that if the applicant were to share mechanisms of technology sharing with the respondent, the same would be in compliance with sharing of costs as well, and not just the benefits, Your Excellency. So if the respondent were to have been provided with means or given any sort of expertise or education or training as to how to as to technology sharing, Your Excellency, the same would be an example of sharing of costs and not just of benefits, Your Excellency, which the respondent will therefore assist the applicant if and when required at a future point in time. Your Excellency, I would also now like to point out Article 21, paragraph 2 of the Accord, which refers to the non-appropriation principle, wherein states cannot make any territorial claim with respect to its spatial areas. Paragraph 3 goes further to state that the surface, subsurface, and resources of the land cannot be subject to proprietary rights. Your Excellency, we submit that any extraction of mineral resources would require some form of ownership or title on the surface or subsurface, both before and after extraction of resources. The Perry-Win Accord.
No, it doesn't actually require ownership. For instance, when the Law of the Sea Treaty was being negotiated in the 1970s, then there were manganese nodules that were expected to be found, and no country was going to be able to have any proprietary rights over any portion of the sea. They would go exploit and leave. And if there was something remained in other parts, then that would belong to others. So exploitation of resources does not mean appropriation of property.
Indeed, Your Excellency. Your Excellency, Article 89 of the Law of Sea Convention refers to the high seas argument and how this has been subject to the res communis principle. Your Excellency, under the res communis principle, the legal status of the surface and the resources is different, which allows for appropriation of resources without having exercised any territorial claims on the surface, so to speak, Your Excellency. However, one must bear in mind the difference between Article 89 of the Law of Sea Convention, referring to the high seas, and Article 136 of the Law of Sea Convention, Your Excellency, which bears in mind that the area of the ocean floor or the seabed, so to speak, does belong to the common heritage of mankind. The common heritage of mankind, Your Excellency, I would like to point out as under page 304 of the compendium. Your Excellencies, I would therefore like to read, to the hitherto tripartite division in international law of the world into national territory, res nullius, and res extra commissarium, the areas which by law are not susceptible to national appropriation, there is now a fourth category, the common heritage of mankind, areas which are not only in themselves not subject to national appropriation in a territorial sense, but the fruits and resources of which are also deemed to be the property of mankind at large. Your Excellency, this doctrine is crucial to understand that the legal status of the lunar surface, as also the resources, attained a similar legal status, Your Excellency. Therefore, the principle of common heritage of mankind is very different from that of res communis, and therefore the law of seas analogy will not be the most appropriate analogy in the present circumstances, Your Excellency. Your Excellency, I would now like to proceed with the last member of my argument, which is in respect of the common heritage of mankind, Your Excellency. Your Excellency, this doctrine, although has attained the status of customary international law in respect of a general obligation, if not a specific legal obligation. Your Excellencies, if I may draw a parallel to the law of sea convention yet again, there was contemplated a mandatory benefit sharing mechanism under the law of sea convention, Your Excellency, by two methodologies. One, by providing for any licensee who wants to pursue activities in the ocean floor or the seabed was expected to compulsorily transfer technology to a developing nation, Your Excellency. The second method was that any operator, if he were to identify a feasible site on the ocean floor, would also have to identify an identical site to that of a developing nation to provide a developing nation with a similar opportunity that the developed nation has, Your Excellency. Therefore, in the common heritage of mankind doctrine, benefit sharing forms a crucial essential that has to be complied with in order to fulfill the essentials of the doctrine, Your Excellency. Therefore, I would like to, in summary, therefore state, in conclusion, with regard to my issue, Your Excellency, that the applicant will not be entitled to undertake the impugned activity, as the same would be in derogation of the non-appropriation principle. However, in the alternative, any mining activities can only be undertaken if a positive benefit sharing mechanism is contemplated, which could be by way of an addendum to the said agreement. Therefore, under the present provisions of the Peruvian Accord, the applicant will not be entitled to a benefit sharing mechanism, will not be entitled to conduct the activity in question, Your Excellency. It was a pleasure and privilege arguing before this court, Your Excellency. I would now invite my co-agent to continue with her arguments.
Yeah. One minute. Yes. Anil, go ahead with the marking.
Yes.
Yes.
Very good evening to the honorable members of the court. Agent seeks permission to address the bench collectively as Your Excellency and individually as Your Excellency.
Yes, go ahead.
Much obliged. It is my pleasure to present before this honored court the following submissions on behalf of Federal Union of Erudnitis. As already indicated by my co-agent, I shall be utilizing the next 18 minutes of this court's time to establish question 1 and 3 respectively. Your Excellency, the applicant have grossly misled the bench with respect to the facts and circumstances of the present case. The agent for the respondent shall clarify the same in due course of the argument. Your Excellency, question 1 deals with whether the respondent is liable for space debris and the damage caused to the applicant due to the disintegration of Simpan. This issue shall be addressed in a threefold manner. The first dealing with non-apportion of liability onto the respondent under the Outer Space Treaty and exoneration from liability under the Liability Convention. Second, applicability of force majeure doctrine. And finally, that the respondent cannot be held liable for the space debris in outer space. Proceeding with the first limb, Your Excellency, Bin Cheng once said, and I quote, "A finding of liability always entails responsibility, while a finding of responsibility does not necessarily entail liability." Your Excellency, Article 6 of the Outer Space Treaty is worded in such a manner that it only ascribes responsibility. In the instant case, the respondent has supervised Project Simpan throughout when it was under its control.
But there is reference
Your
to
Excellency,
absolute
if you may
liability.
refer.
But there is reference to absolute liability.
Indeed, Your Excellency. However, in the instant case, the respondent are seeking exoneration from absolute liability by invoking Article 6 of the Liability Convention. In order to approve the same, Your Excellency, I would like to draw your attention to page number 7 of the compromise, paragraph number 6. The chief scientist of ESRO, Mr. Ekin Trikos, has tried to simplify the technical terminology of the project plan in simple words for every individual to be able to understand. Furthermore, ESRO has published a press release stating that they have faced certain minor setbacks during the test launches. Thus, complying with Article 11 of the Outer Space Treaty, that is to disseminate all necessary information to the public and international communities. Furthermore, Your Excellency, if you may now refer to the compendium, page number 36. Articles 2, 3, and 4 of the Registration Convention were also complied with. There was full and open access to the information on SIMPAN, and even if the applicant could not procure the same data from under the Registration Convention, they could refer to the UNOSA official website, wherein there is a secured page of registry where all necessary information is there in the public domain. Thus, in case if the applicant had queries or was uncertain if the project would have caused certain problems, they could have sought consultations with the respondent on the same by invoking Article 9 of the Outer Space Treaty. Your Excellency, in the present case, the applicant hasn't done so. If Your Excellency is convinced with the argument, may the council proceed further. Much obliged.
Yes.
Much obliged. Your Excellency, strict foreseeability cannot be the criteria under space law. Some form of damage can be assumed, but not the actual form of damage can be foreseen. Hence, it is submitted that under the Outer Space Treaty, it does not apportion liability upon the respondent. Now, with respect to liability convention, the applicant have invoked the doctrine of absolute liability as per Article 2 of the Liability Convention. Your Excellency, if you may refer to the compendium, page number 28. In the present circumstances, the respondent is exonerated from liability by applying Article 6 of the Liability Convention, as there was wholly or partially gross negligence or omission on part of the applicant. Now, Your Excellency, if you may refer to compendium page number 23, the applicant should have complied with Article 5 of the Astronaut's Return of Objects Launched into Outer Space Agreement. Now, this required that the applicant had to notify the respondent and the Secretary General of United Nations if they received any information or discovered a space object or its component parts in their region. Furthermore, paragraph 4 of the article states that if the applicant was aware that the object was of hazardous or of deleterious nature, they must have immediately notified the respondent in order to take effective steps. Your Excellencies, the respondent would have taken any control or damage minimization under the direction and control of the applicant.
Even
However,
if
this act of gross, indeed.
What actions could be taken even if information was given?
Your Excellency, in the instant case, when the debris fell on the surface of the earth, there was a bushfire in the applicant nation's region. And persistently, if you may refer to paragraph number 4 of the compromise, my apologies, if you may refer to paragraph number 6, where it says that it caused a bushfire that spread across millions of hectares. In the instant case, if the respondent was immediately notified about the same, we could have taken control of the bushfires and stopped all the burning down of the flatlands, the pastures, killing of the livestock, etc. There could have been a possibility of damage minimization in the instant case, Your Excellency. This act of not informing the respondent exonerates the respondent from absolute liability as stipulated under Article 6 of the Liability Convention, Your Excellency. If Your Excellency is satisfied, may the agent proceed with her arguments?
Yes.
Much obliged. Your Excellency, the applicant have raised the Soviet Cosmos incident with respect to the Claims Commission. It is brought to your notice. It is Article 18 of the Liability Convention, which speaks with respect to the Claims Commission. In the instant case, they have not constituted a claims committee in order to ascertain the damages and hence cannot claim any amount whatsoever. In the Soviet Cosmos incident, the Canadian government had claimed for $6 million Canadian dollars. However, they were awarded with $3 million Canadian dollars only after the claims committee ascertained the actual damage. Your Excellency, with this completion, I would like to move to the second limb of my argument with respect to applicability of doctrine of force majeure. In the instant case, the respondent is precluded from any liability under the Perevan Accord. If you may refer to the compromise, page number 15, with respect to Article 47, the accord clearly states that a party shall not be liable for any failure to perform its obligations due to an impediment beyond its control. In addition to this, we rely on Article 23 of RCWA, which envisages force majeure situation precluding wrongfulness. Your Excellencies, the doctrine of force majeure has been accepted as a general principle of law and is also recognized as customary international law. If you may refer to the compendium, page number 78, under RCVA, there are 3 elements which are to be met in order to invoke force majeure. First, that there must be the act must be brought by an irresistible force or an unforeseen event. In the instant case, a week after the launch of Simpan, it broke apart. That was the unforeseen event. Second, it must be beyond the control of the concerned state. In the instant case, there was a communication breakdown and the respondent had no control over Simpan. And thirdly, material impossibility in the present circumstances to perform its obligations. Since it was unable to track the satellite, the respondent was unaware if the satellite was falling on the surface of the Earth or was revolving in outer space. Your Excellency, the breakdown of Simpan was a natural event. There was unavoidable or impossible to overcome. Thus, the respondent is precluded from any liability.
Not a natural event.
Your Excellency, in the instant case, during the conduction of test launch, there was communication breakdown. However, 1 week after the launch, the primary and the backup star sensors failed, which led to a disorientation and furthermore communication breakdown. Your Excellency, this was unforeseen in the instant case, an unavoidable event on part of the respondent and which could not be overcome, Your Excellency. And with respect to the natural event, Your Excellency, the respondent had not foreseen this activity, and due to gravitational pull, the space debris fell on the surface of the Earth, which is the natural event, Your Excellency. If Your Excellency is satisfied, may the Council proceed with the last limb pertaining to this argument. Much obliged. Your Excellency, the respondent cannot be held liable for the space debris in outer space. It is brought to your notice that there exists no uniform state practice and there is lack of opinio juris with respect to application of debris mitigation guidelines. I would like to cite the example of China, which is a major spacefaring nation, who despite adopting debris mitigation guidelines, has created space debris in the low Earth orbit through the ASAT tests. There is no liability for creating space debris, Your Excellency. Now, if you may refer to compendium page number 1041, the General Assembly and the UN Corpus has described these guidelines as voluntary. Therefore, there exists no mandate per se to adopt these guidelines onto the respondent. Your Excellency, the agent also submits that there exists no duty to preventing transboundary harm in outer space. Your Excellency, this said duty is expressed under Article 21 of the Stockholm Declaration, which deviates extensively from customary international law laid down in the Trail Smelter case. However, in the instant case, extending the duty to territories which are not under the state control, that is the global commons, this duty cannot be represented, Your Excellency. And thus, I would like to summarize stating that in the present situation, the respondent has been diligent and responsible while carrying out the space activities. However, due to unforeseen circumstances, which were beyond the respondent's control, cannot lead them to be held liable for space debris and damage caused to the applicant. If Your Excellencies are satisfied with this issue, I would like to move on to question number 3.
Yes.
Your Excellency, question 3 deals with the alleged militarization in the region of New Pereira by the applicant and the validity of countermeasures undertaken by the respondent. Your Excellency, militarization of New Pereira amounts to threat or use of force. If you may refer to the compendium page 1308. The essentials of Article 2, paragraph 4 of the UN Charter are that first, it must be threat or use of force, and second, it must be against the territorial integrity and political independence. This provision is considered as customary. Your Excellency.
Territorial integrity or political independence.
Indeed, my apologies, Your Excellency. My apologies. Territorial integrity or political independence. Your Excellency, this provision is considered as customary international law and as such is binding erga omnes. Your Excellency, furthermore, under the Article 2, paragraph 4 was elaborated as a principle of international law in the 1970 Declaration on Principles of International Law. Your Excellency, if you may refer to compendium page number 1099. These principles expand to establish wars of aggression constitute a crime against peace under international law. The states must not threaten or use of force or deprive people of their rights. Also, states must refrain from military maneuvers in another state's territory. Your Excellency, the applicant has no right to intervene directly or indirectly for any reason whatsoever in the internal or external affairs of the respondent nation. Consequently, armed intervention and all other forms of interferences or attempted threats against the state are condemned and in violation of international law. Your Excellency, at this juncture, we would like to apply the concept of effective situation. Respondent from last 20 has been launching missions building new and political independence because it entitles the state to choose and implement their own political and economic social systems without any outside interference. Your Excellency, the actions of the applicant in the present situation with respect to deploying the army and building a military base along with deploying warship clearly violates Article 5 of the Peruvian Accord, which prohibits such activities on the island. Your Excellency, the applicant has breached the principle of non-intervention under the declaration, thereby fulfilling the elements of threat or use of force under Article 2, Paragraph 4 of the UN Charter. If Your Excellency may now refer to compendium page number 1423. We would like to place reliance on the Crimean situation, where the Russian forces in Crimean region moved beyond permitted bases and areas to take control directly or indirectly of the peninsula, which culminated that the president fled away from the country and a new government taking over control. Your Excellency, this was described blatant breach of the United Nations Charter and a threat to intervention only because the applicant has disregarded the letters addressed to them from the respondent nation, condemning their actions and requesting them to put an end to it. Hence, these gestures constitute as a threat or use of force and possible situation where the applicant can take over the launch base of the respondent. Your Excellency, threat or use of force can be utilized only under two circumstances. That is, first being when it is authorized by the Security Council, and second, in situations of self-defense. The applicant does not fulfill this yardstick and the test laid down in the Caroline case. Hence, it is incorrect on their part to use threat or use of force against the respondent. Your Excellency, in the instant case, there was no armed attack on the applicant for them to retaliate with threat or use of force against the respondent. Furthermore, Your Excellency, my apologies, in arguendo, even if there is an admission to self-defense, the applicant has failed to meet the procedural mandate under Article 51 of the UN Charter, whereby they ought to have reported the Security Council immediately. Your Excellency, in addition to the earlier submissions made, the agent would also like to add on body cavity searches conducted by the applicant to negligence or violation of human rights. Your Excellency, fall within the ambit of militarization and are state actors. In the present case, the evidence procured through...
They have said that that there's no evidence that of who's done these body cavity searches.
Your Excellency, in the evidence which is procured by the respondent is with respect to the Erev personnel. They are reliable and they also hold probative value as if the personnel were government officials and were on official duty when they encountered these strict body cavity searches on themselves. Secondly, the evidence holds probative value as it is corroborated with the existing militarization in New Perivia. Hence, the body cavity searches were done by the applicant nation, Your Excellency. If Your Excellency is satisfied, I would also like to bring on the point with respect to how it has violated other forms of convention and law. Much obliged. Your Excellency, under Article 7 and 17 of ICCPR, body cavity searches are gross violation of right to privacy, dignity, and it is also considered as an inhuman treatment, along with Article 5 of UDHR. Your Excellency, they have also violated and acted contrary to the directive issued by the World Medical Association. If Your Excellency may refer to the compendium, page number 1493. Your Excellency, in the case of X versus Argentina, body cavity searches were conducted on prisoners, and it was held that there must be a prior judicial order authorizing law enforcement agencies to take such type of action. Furthermore, Your Excellency, if you may refer to the compendium, page number 1488. The UNHRC committee report against torture mandated for an independent monitoring mechanism, strict judicial scrutiny in such circumstances. Therefore, Your Excellency, militarization of New Perivia by the applicant qualifies as threat or use of force under Article 2, Para 4 of the UN Charter, as the persistent military activities by the applicant have caused havoc in the region of New Perivia, thereby threatening the territorial integrity and political independence. Now, coming to the second limb with respect to validity of the countermeasures undertaken by the respondent, Your Excellency, Countermeasures are responses to internationally wrongful act. In the instant case, the militarization by the applicant led to the respondent to take valid countermeasures by withdrawing support from PERINAV and all the ongoing projects with the applicant nation. Your Excellencies, if you may refer to RCWA Article 49, it lays down the objects and limits to countermeasures. In the instant case, the respondent has faced an injury by the militarization of New Perivia, and the respondent has chosen lawful and effective countermeasures. This part shall be dealt in a twofold manner. First, with respect to the procedural requirements being complied with, and second, that countermeasures were proportionate and valid. Your Excellency, Article 52 of RCWA lays down the conditions relating to resorting to countermeasures. Furthermore, in the case of Gavchikovo, conditions were laid down. If you may refer to page number 1501 of the compendium. In the present situation, the respondent through the External Affairs Minister has issued a letter to the applicant notifying if the military maneuvers would not end, they shall take an action. Instead of replying, the applicant ignored the letter and stationed 2 aircraft carrier warships in the waters of New Perivia. Furthermore, around December 2018, the tensions escalated between the two nations and yet another warning was proposed to them. However, it was futile, due to which in January 2019, the countermeasures were undertaken. Your Excellency, in the instant case, countermeasures are proportionate and valid, as the respondent has taken these measures without using use of force, solely because they wanted the applicant nation to comply with their international obligation without using force. Also, to add on, the countermeasures are temporary in character and reversible in effect. Your Excellency, the respondent has undertaken valid countermeasures under international law, and hence, due to the paucity of time, Your Excellency, I would just like to end with respect to the prayer. If you could move to page number 30 of the memorandum for respondent, I would like you to take the prayer on record, Your Excellency. Thank you. It was a pleasure and privilege arguing before this honorable court.
Yes.
Your Excellencies, I would like to submit the rebuttals on behalf of the applicant.
Yeah. Anil, let him rebut.
Yes, yes, please.
Much obliged, Your Excellency. Your Excellency, the respondents have claimed that the applicant's lack of providing notice of the presence of space debris on the territory qualifies as an act of grave gross negligence. However, Your Excellency, it is to be understood that the space debris did not just confine itself to the applicant's territory, but rather it fell over the entire region of Perivia, which caused damage to the Erevnation, to a steel plant in the Erevnitis territory. Therefore, as the purpose of the notice has already been served, the obligation of the applicant to serve a notice would be redundant. Furthermore, Your Excellency, comparing this negligence, if it may so be called, against the negligence of the respondent in sending up a defective mission, clearly shifts the stance into favoring a higher degree of negligence on behalf of the respondent rather than that of the applicant. Therefore, Your Excellency, it is submitted that the respondents have failed to establish the very high standard of gross negligence which is required for exoneration from absolute liability. Furthermore, Excellency, the fact that the respondent did not adhere to the standards of due diligence causes the disintegration of the SIMPAN to be a foreseeable event, which was within the control of the state. Therefore, Excellency, they are not exempt from liability under the provisions of Article 47, as they could have easily prevented this event had they exercised the proper due diligence standards. Furthermore, Excellency, it is submitted that the common heritage of mankind is not a general principle of international law, but rather it requires an international regime for its enforcement. There is no provision in the accord which provides for the establishment of an international regime. Article 11.5 of the Moot Agreement does provide for an international regime, but it is to be noted that both the states are not parties to the Moot Agreement in the first place. Your Excellency, furthermore, there have been state practices in the instances of acts passed by the United States of America, Luxembourg, etc., that have allowed for commercial purposes of mining, but have not been criticized to be in violation of the principles of the OSC. Furthermore, Excellency, respondent cited the case of Crimea. But in the instant case, it is to be noted that in Crimea, there was an explicit demand for sovereignty. There was an explicit demand that this explicit statement that this was a threat of force, and therefore in such circumstances, it was considered to be a threat of force. In the instant case, there is no such explicit statement of the applicant's intention to pose a threat of force, but rather it comes under the peaceful purposes under article as permitted by Article 5 of the Accord. Furthermore, Your Excellency, if I may take a moment to complete my submissions, the notice to offer was not done in good faith. It was not an offer to negotiate, but rather it was a threat that the respondents would respond and consider the applicant to be engaged in a war with the respondent, Your Excellency. That cannot be considered to be an offer to negotiate in good faith. With this, I conclude the rebuttals on behalf of the applicants, Your Excellency.
Okay.
Much obliged, Your Excellency.
Your Excellency, I would like to make a humble request as to making a rebuttal to that made by the applicant, Your Excellency. If the same may kindly be granted, I would like to use this opportunity.
Yes.
Much obliged, Your Excellency. Your Excellency, applicant made reference to how the commercial activities on the lunar surface have not been objected to. However, Your Excellency, I would like to place reference to Russia's objection before the UN Corpus, wherein they objected to the specific legislation enacted by the US government, the title Commercial Space Launch Activities Act, which allows for appropriation of resources to individuals, Your Excellency. Therefore, there has been observation within the UN Corpus objecting to commercialization of the outer space because of the absence of a legal regime, Your Excellency. Therefore, it could not be assumed that nobody is objected to the same, and therefore the applicant may be permitted to do the same. During the course of the oral arguments, Your Excellency, the applicant made reference to how there has been no factual reference, there's been no reference in the factual matrix that would state that the applicant will pursue activities to the extent of exhaustion of resources. However, page 7, paragraph 7 very much says, we are the only ones who can get it all, which is a statement made by Mr. Arthur Plusios, Your Excellency. Therefore, Your Excellency, the applicant has grossly misled this honorable bench. Furthermore, Your Excellency, the word exploitation that the applicant benefited in interpretation of Article 18 of the Accord would not be the same as exploration and use, as exploitation would be more than mere exploration and use and would be the nature of systematic appropriation, Your Excellency. Therefore, under Article 18, exploration and use would not be the same as exploitation, and the applicant cannot benefit with that provision to say that they will undertake commercial activities on the lunar surface, Your Excellency. My last submission would be in regard to the applicant having placed heavy reliance in respect of the helium-3 as an element that would benefit the applicant as a substitute for fossil fuels. Your Excellency, this element in its practical implementation of conversion to non-renewable energy involves extremely high transaction costs. In order to undertake the reaction of nuclear fusion, Your Excellency, the temperature in question requires 100 million degrees Celsius, which is as under the sun, Your Excellencies. Therefore, to attain a similar temperature on the surface of the Earth has currently been impossible and only possible for a very brief period of time in the example of a hydrogen bomb, Your Excellency. The transaction costs involved to practically translate helium-3 to an energy resource is extremely high, Your Excellency. The applicant may very well mine other available resources on the lunar surface, such as manganese, thorium, platinum, palladium, and appropriate the same and conveniently state that it is for the benefit of mankind at large, Your Excellency. I would, with this submission, come to the end of my rebuttal. I thank you for this opportunity, Your Excellency.
Yes.
Thank you to all the participants for a very good round. We shall now be moving the judges to the judgment deliberation breakout room, if that's all right. Much obliged.
It's a point well taken. Yes, of course, we can't afford to lose time. I'm just saying between now and Tuesday, I would much rather let's wait for a day. Tomorrow is is a holiday. And
those are basically responses to the authorities, the ICSE board and the IGSE board. Saying that these terminated
yes,
responses that they have added, so they are pretty straightforward. We are not saying anything that is completely not said before.
yes.
Okay, so but if I can just say that is bringing it to the notice of the board that there is a discrepancy in at least the termination is not legal. They are taking legal proceedings. So steps should be taken based on the request to cancel the variations. It is quite simple and straightforward.
Yeah, I actually you're right. That may go. respond to it as per the law. And later on, as we go along, there will be an opportunity.
Yeah. So, Rohan, just ask her whether she has received my email.
Sure, sir. I'll do that. Just a second.
She has
yes, sir,
received?
we have. Yes, sir, we have.
Okay, okay.
Thank you for a very good round to both the judges as well as the teams. The team that represented the applicant is Team A, the West Bengal National University of Juridical Sciences, and Team B is the School of Law Christ that represented the respondent. It is evident that both teams have researched sincerely on international law to argue before this distinguished bench. I would now like to invite Dr. Vaidya, the principal of Government Law College, Mumbai, who has been a pillar of strength and a source of support for the Moot Court Association, to kindly address the audience.
Rohan, you are in which year?
So I'm in my second year.
Oh.
Salute to Ma Saraswati. Honorable Mr. Justice R.M. Sawant Sahib, trustees of the D.M. Harish Foundation, esteemed professors, participants, and students.
Wazifdar Sahib पण आहेत. Wazifdar Sahib पण आहेत.
Yes, Honorable Chief Justice S.J. Wazifdar Sahib also. Very good afternoon, good evening to one and all. As you all know, Government Law College has been established in the year 1855, currently in the 165th year of its glorious existence, has enriched the legal fraternity with some of the best legal personalities. Government Law College has been affiliated with the University of Mumbai since 1860 and is the oldest law college in Asia. It was our honor to host the D.M. Harish International Online Moot Court Competition, India's first international moot court competition from last 22 years. This moot is renowned all over the world for the quality of the judges and the participants. Over the years, it has seen the keen participation of the number of teams from across all continents. Just like the past years, this year too, the compromise of the competition dealt primarily with issues relating to public international law, highlighting the emerging legal landscape, and was drafted by the experts in the field. I would like to thank honorable judges for gracing us with their presence and agreeing to be judge of the final round of arguments. I'm thankful to the trustees of D.M. Harish Foundation, respected Shri Anil Harish Sir, Mrs. Shobha Jaktiani, Shri Harish Jaktiani, Mrs. Hani Harish, and Mr. Sharan Jaktiani for extending their cooperation and in making this competition a success. I congratulate the Moot Court Association on successfully conducting an international moot court competition on a virtual platform in this COVID-19 pandemic situation. And here I take the opportunity to declare the prize of best speaker of this competition. It goes to Miss Twinkle Jadwa of Christ School of Law, Bangalore. I congratulate her personally. And lastly, I would like to thank the participants for all the efforts they put in to do their best in this moot and provide us with such meaningful and insightful rounds. Congratulations to the winners and to those who did not win. Keep working hard and you too will one day be there. We hope that you enjoyed the experience and we hope to see you again and again in the coming years. Thank you. Thank you very much.
Thank you, ma'am. Honorable Justice Vazifdar enrolled as an advocate of the Bar Council of Maharashtra and Goa in 1980. He practiced civil, constitutional, company, and arbitration cases in the Bombay High Court. In January 2001, he was sworn in as the judge of the Bombay High Court, and in 2016, he was sworn in as the Chief Justice of the Punjab and Haryana High Court. We would like to thank him for his presence in today's moot court competition.
Honorable Justice R.M. Sawant graduated in 1980 from Government Law College, Mumbai. Justice Sawant has represented the government of Maharashtra in various suits, land references, sales tax references, arbitration petitions, as well as writ petitions, touching subjects like constitutional provisions, the environment, service regulations, municipal, as well as criminal laws. Some of the landmark cases handled by him are protection of the Sanjay Gandhi National Park, Borivali, project of the Mumbai-Pune Expressway, and project of the Worli-Bandra-Narman Point Sea Link. Justice Sawant was sworn in as a judge of the Bombay High Court in 2006 and retired in 2018. I would now like to request Honorable Mr. Justice Sawant to address the audience.
Yes, my esteemed colleague, Justice S.J. Vazifdar, who could not actively participate because of last-minute difficulty which has arisen. The principal of the Government Law College, Dr. Asmita Vaidya, faculty members of the Government Law College, the office bearers of the Moot Court Association, all the participants, and especially the finalists. It always gives me great pleasure when I am invited for a program concerning the Government Law College. Hence, when Mr. Anil Harish called me up and asked me my consent for being a judge for the final round, I readily agreed because I am an alumni of the Government Law College, and as you heard Rohan saying, I am from the 1980 batch, so it is almost 40 years down the road now for me. The moot court is in a way a training ground for budding lawyers, as it lays emphasis on the qualities that a good lawyer requires to possess to succeed at the bar. By assigning marks for the said qualities, the said qualities are sought to be given importance. I must say that I am amazed by the quality of debating, and that too in a subject involving international law, which we are not really very conversant. After going through the papers sent to me, I was remembering the science fiction Star Wars. Having regard to the subject, I am doubtful whether I would have done as well as the participants who were before us a few minutes back. I take this opportunity to congratulate and thank the DM Harish Foundation for holding this moot court competition every year. But this one, I think after a break, I'm sure they would continue to do so as they did in the past. I once again thank the Moot Court Association and the DM Harish Foundation for having invited me to be a judge for the final rounds. Thank you.
Thank you, sir. This competition is indeed a fitting tribute to the late Mr. D.M. Harish, in whose memory it is hosted. The trustees of the D.M. Harish Foundation have over the years established a bond with this college, which goes beyond just this competition. Mr. Anil Harish, Mrs. Shobha Jagtiani, Mr. Harish Jagtiani, Mrs. Hani Harish, and Mr. Sharan Jagtiani have been present with the Moot Court Association throughout all of its endeavors. I would now like to request Mr. Anil Harish to kindly address the audience.
Honorable Mr. Chief Justice Waziftar, Honorable Mr. Justice Rajendra Sawant, Dr. Asmita Vaidya, Principal of the College, Professor Sonali Mathur, and Professor Kishu Daswani, and other professors of GLC, Ms. Ruchi Vagaralkar, and members of her team, fellow lawyers, and fellow students, because we must remain students all our lives. This year, the Moot Court competition has moved into a new orbit. It is the first time that it has been held virtually, with 17 teams participating from all over India and one from Sri Lanka. But unlike the Simpan, there has been no loss of orientation and no break in communication. And although there has been an unprecedented force majeure event, this has not curbed the enthusiasm and spirit of the organizers and the participants and of the honorable judges who have taken part and of the lawyers and of the college. It is said that a lawyer has to live like a hermit and work like a horse. That is even more true today than ever before, because we can see that all of the students who have participated have indeed worked so very hard, and yet they've had to live like hermits with very little contact with the outside world. We are very honored and particularly grateful to Honorable Chief Justice Waziftar, who, in spite of a personal difficulty, has still been here and has observed much of the arguments today. He responded immediately when I requested him last week, and he has actually come on and spent so much time on this. He prepared for it, but could not participate in the event fully as he would have liked to. I am very grateful also to Justice Rajendra Sawant, who also responded immediately. I spoke to him last Sunday, and he said yes, he would participate. He was also to go out of town, but he stayed here, and he has been very active. He's read all the papers, and we saw the questions that he has asked. Thank you so much for having judged this competition. Today really has been, although it is a Sunday, it has been a working Sunday for you. Albert Camus said, "Real generosity towards the future consists in giving all to what is present." Your Lordship has so generally bestowed your time, knowledge, and energy and asked very probing questions. Many senior counsel and advocates have so willingly come forward and judged the rounds. It has been a treat to sit with them, but it has also been heartbreaking to take the place of a judge and then to have to decide that someone very capable actually will not proceed to the next round. Our admiration and respect for the judges goes up every time we participate in a moot court competition as judges. It is so difficult to draw that fine line from out of the gray matter between what is black and what is white, and who's going to go ahead and who is not going to. Because very often the facts and circumstances and the law are so evenly balanced, and yet one needs such great clarity of mind and being able to step back and view everything objectively. That too is a great quality, and we thank the judges for having done all this, not only in this moot court competition, but for so many years of their life and helped so many people in the cases that have come up before them. Thank you very much. The case itself was excellently drafted by Ms. Divya Alexander and settled by Mr. Sharan Jagtiani, Senior Advocate. It was a challenge not only to the student advocates, but also to those who judged, as it contained many complex facts and unusual issues. I'm very grateful to the professors, Professor Sonali Mathur, who has spent so much time on this, organizing and directing behind the scenes and judging, and to Professor Kishu Daswani, who has also judged and has always been a great support. Also to the students who authored the bench memorial, Mr. Rohan Shah and Ria Narichania. And to all the student advocates from 17 universities and colleges from all over India and from National Law College, Nepal. I can only imagine the many hours of the many days of the many weeks that they've spent studying the problem and doing research. I'm sure that the ability to prepare so thoroughly has become a part of your psyche and that it will stand you in good stead in the future. So even if you've not got a prize, remember that in education, there is no loser, everyone is a winner. The Moot Court competition has been organized so thoroughly by the Government Law College, MCA, with the constant and positive support of the principal, the professors, and the staff, and to those who have been members of the committee in the past. We are very grateful to all of you. The members of the association headed by Ruchi have worked so hard and have attended to every detail, including preparing a souvenir and comparing the competition. The real value of the competition is to show that barriers must be broken, and students and all of us should see that mutual help and cooperation is the only way forward. I hope these interactions that we have had, although not personally this time, will help us to understand each other and the different points of view that are possible and to build bridges. I'm very grateful to all those who have participated in and been involved with this competition and have encouraged all of us. George Bernard Shaw said, "It is the duty of each one of us to ensure that the candle burns more brightly when we pass it on than when we received it." Your lordships, professors, advocates, and friends, thank you for doing just that.
Thank you, sir. Before beginning with the valedictory function, I would like to thank Mr. Pradeep Jadhav and Mr. Arjit Khair, who have stood by the Moot Court Association as a pillar of strength through all our endeavors for the last many years.
We shall now be announcing the results of the competition. All winners will be receiving a cash prize as well as digital certificates. That being said, I would like to request Ms. Rishika Harish to announce the award for second best memorial.
The award for second best memorial goes to the National Law Institute University, Bhopal, which is team code Q, and the members of the team are Rishitosh Kumar Akshay, Yash Dayal, and Ms. Pooja V.
I would request Mr. Adiraj Harish to announce the award for best memorial.
The award for the best memorial goes to School of Law, Christ, Bangalore, Team B. The teammates are Ms. Buddhi Nishita Gauri, Ms. Twinkle Chadwa, and Mr. Varun Zaffarino. Congratulations.
I would also like to request Mr. Adiraj Harish to announce the award for second best speaker.
The award for the second best speaker goes to Ms. Anjana Raghunath of the West Bengal National University of Juridical Sciences, Kolkata. Many congratulations, Anjana.
I would also like to request Mr. Anil Harish to announce the best speaker in the final rounds.
The best speaker in the final rounds is Ms. Twinkle. Is that right?
That is correct, yes.
Congratulations. You were very good. I heard you yesterday and today.
I would request His Lordship, Justice Sawant, to announce the award for the runners-up team and the winning team.
I don't know their.
Your Lordship, if you could just check the chat box, I have sent them to you.
Give me the name. No? Okay, Anil, you do it.
I also cannot see it. I'm not familiar with it.
That is a problem.
Sir, if you could just give me a minute, I can message it to you, sir.
Yes, message it to Justice Sawant, please.
Yes.
Your Lordship, I have sent a message on WhatsApp to you.
Okay, on WhatsApp. You. Okay, now the runners-up team is West Bengal National University of Juridical Sciences, Kolkata. And the best team is School of Law, Christ, Bangalore. It should be Bengaluru, not Bangalore. काय निंबाळकर हे बेंगलुरू असलं पाहिजे.
Apologies.
Anyway, yes.
Congratulations to the winner.
Thank you so much.
Yeah.
Thank you so much, ma'am. So everyone, even the MCA for GLC, it was a very smooth process despite it was held online. We did not face any difficulties. And it was
Madam,
a very,
in
really
case
nice
you become a
enriching
lawyer, you
experience.
look at the papers. Huh?
Indeed,
you have got
indeed.
a great capacity to address extempore.
Indeed, Your Excellency.
But when you are appearing for a client, that is not really advisable. Then better you look at your papers, right? Yeah. Okay. Good.
Congratulations to all the participants. It was a wonderful round.
Yes, congratulations to everyone who participated yesterday and today, and to the winners and everyone in the finals. All of you were so good and so clear.
Yes, Devavrat.
Yes, we'll be having the vote of thanks. Ria, if you could.
Professor Sonali Mathur is the professor in charge of the Moot Court Association and also a professor at the Government Law College. Her guidance has been invaluable to the committee and its functioning. We would like to request Professor Mathur to kindly say a few words.
Good evening, respected judges, Principal Dr. Smita Vaidya, trustees of the DM Harish Foundation, esteemed guests and participants. This is the 22nd year of the DM Harish Moot Court competition, which started out as a national moot court competition at the start of the millennium and has only risen from strength to strength, with teams competing from all over the world on extremely challenging problems of public international law each year. The Moot has been a very important event in the timeline of GLC Moots, as it perpetuates the cherished memory of our beloved alumnus, Mr. DM Harish. The importance of mooting as a co-curricular activity for students cannot be overstated, as it provides a holistic opportunity to a student to develop his or her skills as a potential lawyer. We have all witnessed a wonderful example of these skills from two highly competent teams today who have argued on a very complicated problem of international law and space law. I would like to express my sincere gratitude to our judges of the final rounds, Honorable Retired Mr. Justice R.M. Sawant and Mr. Anil Harish. I would also like to thank Honorable Chief Justice Mr. Sawazikar for his presence during the moot today. I thank all the trustees of the DM Harish Foundation, Mr. Anil Harish, Mrs. Shobha Jakyani, Mr. Harish Jakyani, Mrs. Hani Harish, and Mr. Sharan Jakyani. Since its inception in 1954, the MCA, Moot Court Association of GLC, has been committed to promoting, coordinating, and encouraging the activity of mooting at GLC. Given this new virtual format of the moot and its technological challenges, the MCA has once again done an excellent job in organizing the moot. I would like to thank Ruchi and her team for their fabulous work. Thank you. I would also like to thank our participants who have spent months preparing for this competition, and we really hope to see you again the next year. Thank you.
Thank you, ma'am. We have now come to the end of the competition. The Moot Court Association of Government Law College has been organizing around 8 moots per year since its inception in 1954. It is a well-established committee which is managed by students with the help and guidance of all professors and staff members. The General Secretary, Ms. Ruchi Vagralkar, has not only been a great mentor, but has also helped this committee grow and encouraged its members to develop the quality of leadership. We would now like to invite our General Secretary, Ms. Vagralkar, to deliver the vote of thanks.
Thank you, Ria. Honorable Mr. Chief Justice S.J. Vasivdar, Honorable Mr. Justice R.M. Sawant, Mr. Anil Harish, Dr. Asmita Vaidya, Principal of Government Law College, the trustees of the D.M. Harish Foundation, Professor Sonali Mathur, faculty members, participants, ladies and gentlemen. It has truly been a privilege for the Moot Court Association of Government Law College to organize this Moot Court competition annually in memory of the late Mr. D.M. Harish, GLC alumnus, and one of the greatest taxation experts this country has ever seen. The growth and progress of this competition as one of India's finest international Moot Court competition bears the testimony to the constant support, encouragement, and dedication of a number of persons, and this competition would be incomplete without acknowledging their efforts. The Moot Court Association of Government Law College is indebted to Honorable Mr. Chief Justice S.J. Vasildar for his invaluable time. We sincerely thank His Lordship for joining us for the final round of arguments and the valedictory function this evening. I would like to take this opportunity to thank Honorable Mr. Chief Justice, Honorable Mr. Justice R.M. Sawant for gracing us with his presence this evening and for his prompt consent to judge the final round of arguments. I would like to thank Mr. Anil Harish for his constant support as a judge and a trustee in several of the Moot Court Association's endeavors in past. And we once again thank him for his continued encouragement and for consenting to judge today's competition. This prestigious event is truly an outcome of the broad vision of the D.M. Harish Foundation. I take this opportunity to thank all the trustees of the foundation, and in particular Mr. Harish and Mrs. Shobha Jagtiani, for their steadfast faith and support in the MCA. I extend my heartfelt gratitude to Mr. Harish Jagtiani, Mrs. Hani Harish, and Mr. Sharan Jagtiani, the trustees of the D.M. Harish Foundation, for their persistent belief in the association. I would also like to thank Mr. Adhiraj Harish and Mrs. Rishika Harish for their help in making this competition a success. I want to thank the members of the legal fraternity, the advocates, senior advocates, and professors who promptly consented to judge the preliminary quarter-final round of this competition. I would like to thank Mr. Pankaj Sawant, Mr. Pradeep Sancheti, Mr. Mustafa Doctor, Ms. Gayatri Singh, Mr. Sharan Jagtiani, and Professor Mathur for readily consenting to judge the semi-final round of arguments. I sincerely thank Mr. Karthik Jaikumar and Mrs. Ruju Thakkar for judging the memorials of this competition. And I would also like to thank Mrs. Divya Alexander and Mr. Sharan Jagtiani for drafting this year's compromise. I sincerely thank our principal, Dr. Asmita Vaidya, Professor Rachita Ratho, Dr. Ramesh Aswar, Professor Kishu Daswani, and Professor Malika Devendra for supporting us to our endeavors. The unwavering efforts of Professor Sonali Mathur has always helped this competition see a brighter future. Her vision and constant assistance has greatly built this competition to what it is today. I would like to express my sincere gratitude to the former General Secretaries, Ms. Shivangi Adani, Mr. Yash Shiralkar, Ms. Anjali Karuna Karan, and Mr. Bharat M. Mirchandani, and the senior members of the Moot Court Association, Gaurang Samel, Nishta Chaudhary, Akshita Tiwari, and Aditya Deshankar. I thank the entire staff of GLC for their never-ending guidance and support throughout the year. I would also like to thank the advisory board of MCA, Mr. Ruben Vakil, Mr. Firoz Patel, and Mr. Shanay Bafna. And lastly, I would like to thank each and every member of the Moot Court Association for their undying dedication and hard work. I would like to thank the office bearers, Riya Doshi, Riya Narachanya, Vinaisha Hansotia, Ruhan Shah, Aman Saraf, and Abhishek Raj for their vital contribution. I would like to extend my gratitude to all the participating teams, both domestic as well as international, for participating in this competition. And I hope this was an enriching and enjoyable experience. And I truly hope to host you, hopefully in person, in the near future.
Thank you, Ruchi.
Where is this Rohan gone?
So I'm right here. So I think with that, we can end the final round.
No. Now everything is over, or you're going to treat us to virtual tea?
So I don't think that's possible this year.
Virtual, it is possible. Okay. Thank you, Anil.
Should
Thank you very